Good morning. I'm Kathy Webb, and I am serving on the board of the Women for Kansas Education Foundation. And on behalf of Women for Kansas, I want to welcome everyone to this presentation of the rule of law in your life. We have an extremely distinguished panel of presenters, all of whom are appearing via Zoom. And then the program is being streamed live on the Women for Kansas Facebook page to the public. And it will be recorded and then uploaded to the Women for Kansas page for future viewing. It is my great honor to introduce the moderator for today's program, Chief Justice Marla J. Luckert. She has been on the Kansas Supreme Court since 2003 and has served as Chief Justice since 2019. As you might guess from the title, it doesn't get any higher than that. And she is just the second woman in the history of the state to hold that position. In her distinguished career, she has served in many important positions and received numerous honors and awards. After graduating from Washburn Law School in 1980, she joined the firm of Goodell, Stratton, Edmonds, and Palmer in Topeka. In 1992, she was appointed as judge to the 3rd Judicial District in Topeka and later became chief judge of that court. Then she went on to be appointed to the Kansas Supreme Court and has risen to the position of chief. She has served as president of numerous organizations, including the Kansas Bar Association, the Kansas District Judges Association, the Kansas Women Attorneys Association, the Topeka Bar Association, the Women Attorneys Association of Topeka. And she has also served on numerous other national, state, and local boards and committees. It's a long list and very impressive credentials that we have in our chief. Without question, we could not have gotten a more distinguished, experienced, or knowledgeable person to lead this panel discussion than the Honorable Chief Justice Marla Luckert. Take it away, Chief.
Thank you, Kathy. That last comment especially, I won't adopt an imposter syndrome value that many of us often talk about and deflect it, but it is extremely humbling, and I appreciate the very gracious introduction. So, thank you. We are very excited to be here today to commemorate Constitution Day, which is an enormous value to those of us who are every day working towards the goal of justice in Kansas. We have, as Kathy said, titled our program today, The Rule of Law in Your Life, because we think that's a topic you need to understand. And it fits in with Constitution Day because the principles that underlie the rule of law stand as the foundation of our Constitution. Stripped to its simplest terms, the rule of law means the rules that rulers use power following established principles and procedures based on the Constitution. And it's widely accepted that republics such as the United States and each of its constituent states are defined by the rules in their constitutions. So it seems an appropriate way for us to think about Constitution Day. The holiday itself is in large part designed to give a celebration, not only of the fact and a commemoration of our founders and our history, but also to give us an opportunity to reflect on the Constitution. And taking that advantage of that today, we have some trial court judges and myself and another appellate court judge to give our perspectives about how that rule of law impacts us every day. I'm going to talk in really very broad strokes about what we mean by that phrase of the rule of law. It's going to be pretty theoretical and philosophical, and if you don't like that kind of thing, I apologize a little bit in advance, but I think it's important that you reflect a little bit on that, and I'll tell you more about why I do. But don't fear, because then I'm going to turn the program over to Judge Amy Hanley, who is a district court trial court judge in Lawrence, and Kellie Hogan, who is a trial court judge in Wichita. And both of them are going to give you the perspective, what we sometimes refer to as the trenches. Those are the judges who, along with their colleagues across the state, are processing over 400,000 cases a year in our Kansas courts. They see these principles played out in those courtrooms every day. And finally, Justice Melissa Standridge, who is a member of the Kansas Supreme Court for about a year, and before that served as a judge on our Kansas Court of Appeals, will turn our focus to the importance of the rule of law in the functioning of our republic and of our government, and how it impacts the interplay of the three branches of government. We plan to leave time for questions, but if you would like to post a question on the Facebook chat, those will be transferred to us, and we'll try, as we work through the program, if we can answer them as we go along, we will, or we'll try to return to those as we have time. So what is that rule of law? Much of it, as I said, is something that we talk about in a day, every day. The first opening words of the preamble of the United States Constitution, and those first 17 words define what it is we do each day. Those 17 words are, "We, the people of the United States, in order to form a more perfect union, establish justice." But the importance of those concepts far exceed the bounds of the courtroom. There's something that really do permeate everything in our society. Some argue that the true value of the Constitution is that it establishes a country based upon the rule of law. Philosophers, individuals, and societies for centuries have wrestled with what does that really mean? And most conclude it means something different to me than it does to you, and to you, and you, and you. That each of us, sort of like the definition of the meaning of life, we all have our own definition in a way of what that means. But today's society, I think it's important that we all contemplate what it does mean to us, what it means to us as a nation, and how those views can vary. Because it seems like with regularity on social media and politician speeches, this phrase has taken on its own life. They use it to throw out when they want to criticize someone because they're not enforcing or following or paying value to the rule of law. And then they use it to applaud those with whom they agree. And for us to be critical evaluators of those kinds of statements, we need to have a concept of what that might mean. Given that amorphous value or that amorphous definition, I'm not really sure why I decided to take this on, but I'm buoyed by the fact that I think there are a few principles or standards that almost everyone agrees with. And one of those is in that base definition that I gave you of the rule of the law at the beginning, that in a limited government administering according to the rule of law, the rulers use the power established by principles and procedures based on the Constitution. In contrast, when rulers wield power capriciously, there's a rule by will of an individual or a small group of individuals. The rule of law is essential to every constitutional democracy that guarantees rights to liberty. And as I said, that rule of law in those nations prevails in the government, in civil society, and even in the economy. So another way to say all of that is to say that the rule of law exists in a country when its constitution functions as the supreme law of the land. And when the statutes that are enacted and enforced by the government conform to that constitution. And that describes the United States. The second clause of Article 6 of the United States Constitution says that this Constitution and the laws of the United States shall be the supreme law of the land. And the judges in every state are bound thereby. And the third clause requires legislative, executive, and judicial officers at both the federal and the state level to affirm their support to the Constitution. Some argue that the rule of law means little more than that. Others, including the late Justice Antonin Scalia of the United States Supreme Court, argued explicitly that the rule of law is no more than a law of rules. And many philosophers make the same assumption that the rule of law simply means the government's bound by rules that are fixed beforehand. But most often when we use it, I think most of us, politicians, commentators, scholars, all across the board, see it as encompassing overlapping ideas about constitutionalism, due process, legality, justice, and sovereignty. So trying to boil those down into 10 quick statements, I will try to do it in this way by saying first, no one is above the law, and everyone under the authority of the Constitution is obligated equally to obey the law. Second, laws are made according to established procedures, not according to arbitrary will. Third, governmental power is bound by law. And in large part, this arises because of what I will label as the fourth principle. And that is that the Constitution and other laws grant rights and liberties to us, to each of us. And including in those guarantees are protections of our basic fundamental human rights. So our Constitution limits the government's ability to tread on those rights. And essential to that function is the fact that our three branches of government are structured in a way that we have checks and balances on back and forth between those branches to help prevent each other from overstating our own power or from treading on those rights. And fifth, there's a common understanding from the people about what the requirements are. At least in modern times, that's because they're written down and they're available to us. So I know that if I speed, I'm going to have the risk that I'm going to pay a fine. And I know that while I have certain rights, like the right to exercise my speech as I'm doing right now, there are limitations on that. I cannot, the proverbial example, I cannot run into the theater and yell fire. I can't talk about you in a way that would slander you, or you have the right to come back and seek damages from me for the harm that I might have caused you. So we have a common understanding of the laws and the consequences of violating those laws. And seventh, there are clear and fair processes for enforcing those laws. And closely associated with that, those laws are enforced and equally and impartially, so everyone's rights are respected. We've had a great deal of discussion the last 18 months about how well we are doing on those principles. Are we as a nation meeting those standards? And those are important inquiries for us as we think about the rule of law, as we assess not only where we are strong, but where we have room for improvement. The ninth standard is essential to the viability of those concepts. There must be an independent judiciary where judges and juries are fair and impartial. Judges work for the government. Sure, we do. But we're not law enforcement officers. We're not prosecutors. We don't arrest and try people as in some countries they do. Our role is to see that the court procedures are followed so that both sides follow the rules and that we do so in an impartial manner, and that we are not influenced by public perception or by our own personal views. And to do that, the 10th principle comes into play. The system of justice also must follow rules and procedures. We have standards that we as judges apply. We have tests. There are burdens of proof that we apply in our courtrooms. And as appellate judges, we review the trial court judges to see that that is what they are doing. And all of us work so that we have principles like stare decisis and other, which means that we follow our own precedents so that there are standards. Having that fair and independent judiciary means that the rule of law is respected in our country. where judges are not subject to pressure and influence, but are free to make impartial decisions based solely on fact and law. All of those things are critical to us, and they do impact us in every day, as our next speakers will make more clear to you, I think. So with that, I'll turn it over to Judge Amy Hanley.
Thank you, Madam Chief Justice. Good morning to my fellow Kansans on this beautiful Saturday fall morning. As Chief Justice mentioned a few moments ago, I'm in Lawrence, Kansas. I'm Amy Hanley, a district court judge in the 7th Judicial District. So I'm a state court judge at the trial level. And what that means is that if you were to sue someone in state court, you would see a judge like me. Or if you are charged with a crime, you would see in state court, I should say. If you're charged with a crime in state court, you're going to see a judge like me at the district court level. And right now, my docket or my caseload is made up entirely of criminal cases. And you all know what criminal cases are, thanks to television and the movies. Those are the most public eye type of cases. Everybody keeps up with the criminal cases. And that's what I'm handling right now, which means I also do a lot of jury trials. My focus today is going to be on the constitutional rights that apply in those criminal cases, because some of you may not be familiar with where the constitutional rights of defendants derive from. So I want to talk about how those constitutional requirements and constitutional rights affect me and my job, how they affect defendants, and then how they affect all of you in your everyday lives. So the first 10 amendments to the Constitution are the Bill of Rights, which you're all familiar with. And those Bill of Rights have specific prohibitions on government power, and they protect individual liberties, as Chief Justice was referring to. For criminal cases, the Sixth Amendment is one of the most applicable or most widely used amendments when it comes to the cases in front of me. There are other amendments that apply too. My focus today is going to be on the Sixth Amendment, and I want to cover 3 areas of that. First, the right to have a lawyer falls under the Sixth Amendment. Second, the right to know who your accusers are and know what you're charged with. That derives from the Sixth Amendment. And then finally, I want to talk about the right to a jury trial, which involves the right to a public trial, the right to an impartial jury, and the right to a jury trial without unnecessary delay. So first, beginning with the right to a lawyer. Criminal defendants have a right to have a lawyer, even if they can't afford one. And that's because defendants in America are presumed innocent until proven guilty. We want them to have adequate representation. We want a level playing field. So how does that affect me and my job? I appoint attorneys for criminal defendants who can't afford their own attorney. Of course, criminal defendants can hire their own, but I often do make appointments based on the financial status of the defendant. How does that affect you? Well, we hope that it doesn't, at least not often, but if you were to be charged of a crime and you didn't have the funds to be able to hire your own lawyer, the court has the power to appoint an attorney for you. The next area is the right to know who your accusers are and to know what you're charged with, and have the evidence presented against you. So we commonly refer to this, and this part of the Sixth Amendment is the Confrontation Clause. The Confrontation Clause indicates that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Now, this was written and originally intended to make sure that no defendant was convicted by written testimony alone or by written depositions, and that the defendant would have the right to actually confront witnesses against him or her in a courtroom, face to face. So the Confrontation Clause is what guarantees that, because that's where the defendant's understanding of the evidence against him comes from. The evidence is presented in open court from the witnesses, from the accusers. Now, I would be remiss if I didn't mention that the Confrontation Clause has been a very interesting issue lately, because our world now exists virtually in many ways. We do court hearings virtually, some of them by Zoom or using other platforms. So, I'll spoil the surprise. I'm not going to tell you what the ruling is on Confrontation Clause, but I am going to tell you with regard to virtual hearings, it's a hot topic, because the issue is, is the Confrontation Clause satisfied when witnesses are appearing by Zoom instead of face to face? I will let you know that in Kansas, that's why we're doing jury trials for criminal defendants in person. We're not doing those by Zoom unless a defendant agrees to waive any potential rights and have a Zoom criminal jury trial. And I don't know of one yet, but I'm sure interested to see if it happens. But that's an issue that has come up during the last 18 months, and a very interesting one that has affected us in our jobs. But on a regular day-to-day basis, and before the issue of virtual hearings, how did that affect me in my job? How did the Confrontation Clause affect my job every day? Well, it's what gives me the power to issue or approve subpoenas. Because the defendant has a right to confront witnesses and accusers, I can subpoena people to come to court. And of course, that applies in civil cases too, but my focus is in criminal cases. And the subpoenas go out with the authority of this constitutional right. How does that affect you? Well, this is why I can compel you to come to court. This is why you can be ordered to come to court under a subpoena, because defendants and parties have a right to be able to confront those accusers in court. Now, finally, I want to address the right to a jury trial. And this particular subject is very near and dear to my heart, based on my background as a trial lawyer for many years before I took the bench, and all the jury trials that I've been involved in. As I mentioned, the Sixth Amendment right to a jury trial guarantees that the defendant will have a public trial, right? We want transparency in the system. The public has a right to be able to attend these trials. We don't want trials to happen in secrecy in some dark room away from the eye of the public. That's not what the American system is built on as far as principles. So they happen publicly, which means the media has a right to be present, family and friends, general members of the public. That doesn't mean we have to build courthouses that fit the state of Kansas inside so that every possible person who might be there can come. But it does mean that we need to make sure the trials are public and have reasonable access so that they can attend, and the defendant's right to a public trial is protected. We also, in the Sixth Amendment, have the guarantee that the defendant will be brought to trial without unnecessary delay. This is what's commonly referred to as speedy trial rights. You might have heard that phrase. So the defendant has a right to be brought to trial without unnecessary delay, not without any delay, without unnecessary delay. And that's how we as judges evaluate whether or not a continuance should be granted or when a trial should be set. And then finally, with regard to the right to a jury trial, the defendant has a right to an impartial jury. So we're not going to have people on the jury who are involved in the case or related to the defendant or friends of the prosecutor. We need an impartial jury, a fair cross-section of the community where the defendant is charged. So how does that affect me on a daily basis? That means I can summon you to appear for jury service. And how does that affect you? Again, that's why I can bring you to the courtroom for your civic duty of jury service, which is where I'm going to end my comments today, talking about jury service. I told my colleagues in this presentation that I take every opportunity I can when asked to speak about jury service because of how important it is. And I hope to convince you of two things today. First, of the significance of the role of a juror, and second, the fulfillment of the role as a juror. So with regard to jury service, my knowledge comes from the cases I presided over as a judge, but I was also a trial attorney and did many, many jury trials before that. And that means I know how significant that role as a juror is. And sometimes people will say to me, as a judge, oh, you're the judge who acquitted that defendant. Well, and with the exception of a bench trial, if it were a bench trial to the court, I might have done so. But if it's a jury trial, that's inaccurate. I didn't actually acquit or convict anyone. The jury did. Or when I was a trial lawyer, when I was a prosecutor, people might say, the same thing. Oh, you're the attorney who convicted so-and-so. I asked questions, I made closing arguments, but I didn't actually make the decision. The jury did. You did. And I say you did because many of you will actually have the opportunity to serve on a jury, a criminal case jury, most likely within your lifetime. And that means you have the power to decide whether a defendant is guilty or not guilty. And when I talk about the significance of that role, here's what I mean. We're told that voting is power and has an impact. And it's true, absolutely true. You should vote. It does have an impact. But many times when you're voting, you're one of at least hundreds, if not thousands or millions. On a criminal jury, in most cases, you're one of 12. You're one of 12. And that's a pretty small number, making a very significant decision. That's a lot of power. And to explain it another way, criminal juries have to be unanimous, which means that if only one of those 12, if you don't agree with the others as to, let's say, maybe you don't agree that the defendant's guilty, your vote means that the defendant will not be convicted. Or if you do agree with the others, it means the defendant will be convicted. The power of one juror can convict or lead to a hung jury, perhaps. That is very significant, a very significant role. And then finally, the fulfillment part of it that I want to convince you of is I fully understand that legal matters, whenever you hear lawyers are involved, you probably think, oh, that equals boring, or maybe court always seems boring. At least I thought you might have thought court was boring until the pandemic happened, because a lot of you really like to watch Zoom hearings, which is a surprise to me. But if you are amongst those who find court boring, you might think that way when you have to report for jury service. And I see a lot of jurors who think that way. But I have never seen a juror who is actually selected walking away from serving on a jury to have found it boring or insignificant. Never, folks, never once. Those jurors who get selected immediately feel the weight and the importance of the process. They appreciate the process. They understand what we mean when we say that jurors are needed to make the system fair. They consider the instructions and they decide whether one of their peers in a criminal case is guilty or not guilty, or whether they've been wrongfully accused. It is important work. It is very fulfilling work, because important work is always fulfilling. And that's why I say that jury service is fulfilling. So thank you for having me this morning. I hope I've left you with a few thoughts on jury duty when you get called the next time. At this time, I'm going to turn it over to Judge Kellie Hogan.
Good morning, everyone. I appreciate you taking the time out of your Saturday morning to attend this and to think about the rule of law and our U.S. Constitution. I was appointed by the Governor Laura Kellie as a district court judge in Sedgwick County, which is Wichita, Kansas. I started serving in April of 2020. And it's interesting to note that in Kansas, half of our districts have elected judges, half have appointed. So I started out with an appointment by the governor, but because Sedgwick County elects its judges, I was appointed in April, and then the voters approved me or elected me in November of 2020. Prior to taking the bench, I worked for Kansas Legal Services, which is a nonprofit law firm that assists individuals in our state who have a legal problem but can't otherwise afford to hire an attorney. And I bring this up because Judge Hanley mentioned about criminal defendants having a constitutional right to have appointed counsel. That same thing is not universally true when people have civil cases. Civil cases are cases involving landlord-tenant disputes, divorces, things like that, where a person may desperately need legal counsel, but the government is not required to provide a attorney for them free of charge. And that's where Kansas Legal Services came in, because we had funding to represent some of the neediest people in our community that had civil issues, victims of domestic violence, for example. I've been on the bench now for about a year and a half. And when I think about what does the rule of law mean to me, it means that I follow the law. When I put on my robe and sit in my chambers and hear cases, I don't think about what I want to do or what I think should happen. I look at what the law says should happen. And if the law says I shall do something as a judge, that's what I'm going to do. It's up to the legislature to write the law. And as a judge, I follow the law. Currently, I'm sitting in the family law department. That's a department that many people may have experienced themselves or certainly know someone. The family law department, we hear cases involving divorces and paternity. So a paternity case is a situation where two individuals have a child, but were never married. They're no longer functioning together as a couple, and so they need the court's assistance to make some guidelines about who's going to do what and who's going to pay for what. In a divorce, it's two individuals have come together and made a formal commitment. And if they decide that that's not going to, it's not going to be a viable future for them, they come to me as a judge, they come to the court looking for a fair way to move forward. In many cases, families are able to come to their own agreements. We always hope that in situations involving children, that parents can make their decisions about what's best for their children and what's best for their family. The law even tells us that that's a preferred way. But when the parents can't make decisions, that's when the judge comes in a family law case. And so you may be wondering then, what exactly does this even have to do with the Constitution? And it has everything to do with the Constitution, because parents have a fundamental right to parent their children. And when you think about all the different rights a person has, and what could be more essential than if you have a child, that you are the person who is making decisions about the child, and that the government is not going to get involved in those decisions unless there's a really good reason. So parents have a fundamental right to parent children, but nobody has a constitutional right to harm anyone. Prior to being assigned to the family law department, I was in the child in need of care in the juvenile department, which is a place that I had a lot of experience before I took the bench. So in child in need of care court, we're looking at children who have been abused or neglected by their parents. In order to remove a child from the home, we have to have a really good reason. to do that. And we have a lot of focus on what services can we provide so that the state is not taking children away from family homes and placing them into foster care. So we try to reserve those foster care homes or that severe decision for situations where there's no other choice. In order to parent a child in Kansas, the Constitution says you only have to be adequate. And so when you think about adequate isn't a standard that you would think is what you would want for your own children. You know, you want them to be in the best circumstances all the time, or as a grandparent, or I'm an aunt. I just wouldn't feel satisfied with adequate parenting. But that's all that's required by the Constitution. And so we always, in cases involving children and families, have to be very mindful that adequate, it just means adequate. It doesn't mean that you have to be the best family, that is a fundamental right. And in order to take away someone's rights to parent, in the most serious cases, a parent may be facing the termination of their parental rights. So what could be more serious to an individual than saying to them that you can't parent this child and that we're going to sever that legal relationship? But in order for a judge to do that, a judge has to find clear and convincing evidence that a parent is unfit and that they are unlikely to change in the foreseeable future. So clear and convincing is a pretty high burden. And I know sometimes that it can be frustrating to people to see children who are in foster care doing well with a foster family to be returned to their parents because their parents have corrected whatever deficit led to the foster care situation. For example, many children come into foster care when parents are substance addicted, and ways of the attempts we make to treat that substance abuse without removing children from home are unsuccessful. Sometimes people feel like because a parent was addicted in the past, that really they should lose their right to have any contact with their children in the future. And that's just not the way the law works. We look at what is the issue that brought a person into foster care, and has that issue been resolved? And can that child be cared for adequately by their biological family? In the family law court, parents get to have parenting time with their children. So a lot of times in the animosity of a divorce, parents are tempted, as they work through their own pain and disappointment, to try to use the children in the case as a weapon. But just because the parents don't get along doesn't mean that a parent doesn't have a fundamental right to have a relationship with their child. And because my background is in child welfare, I always think about it as a child's fundamental right to have contact with a parent as well, as long as that can be done in a safe and appropriate manner. A situation that we see in our family law court where the government gets involved with a parent's fundamental rights to make decisions about their children are cases involving grandparent visitation. And so it's maybe many of you are aware of people, grandparents, who think that the biological parents could be doing a better job. Maybe they've picked this school when the grandparent thinks they should have picked that school. There can sometimes be a lot of animosity in those relationships. And so it is actually possible for a grandparent to file a cause of action that is heard in family law court, where the grandparent seeks to have a court order that the grandparent can have time with their grandchildren, even when a parent objects. And so when you reflect back on that, if a parent has a fundamental right to make decisions about their own children and who the children see and what the children do, you think about, so what would need to be present in order for the government or the court to get involved in that decision? And so the US Supreme Court has recognized a grandparent's right to have contact with grandchildren. But before that can be ordered over a parent's objection, I have to find that there is a relationship between the grandparent and the grandchild, and that it would be in that child's best interest to have contact with their grandparent. So a lot of times in the child need of care court where I started, our standard is best interest of the child. As a judge in divorce cases, my standard is also best interest of the child. I also worked on cases involving juvenile offenders. So you may be interested to know that juveniles have also have rights under the Constitution. In Kansas, the juvenile cannot be charged with a crime until they're 10 years of age. But when juveniles come to court in Kansas, they're appointed a court-appointed attorney. They have a right not to make statements against their own interests, so they don't have to incriminate themselves. We do make some provisions. It can be very interesting because for an attorney in a juvenile offender case, the juvenile is the client, not the parent. And so parents are used to being involved and making decisions. And so as a lawyer or as a judge, sometimes we've had to say to parents, this is actually your child's case, and your child gets to decide these things. We certainly encourage children to consult with their parents before making decisions, but it can be pretty offensive to a parent when you as the lawyer need to speak with a juvenile offender about a crime they're accused of, and you're telling the parent, I'm sorry, ma'am, you're just going to have to step out of the room while I talk to your child. That's can be a very uncomfortable position for people. But oftentimes other lawyers don't think that cases involving children, so cases in our juvenile court or cases in family law court are very important, or that they're constitutionally significant. And from my perspective, what is more important than working on cases involving children and families? And that we deal with the Constitution every day and in very practical ways. And with that, I will turn the forum over to Justice Standridge. Thank you.
Good morning. I'm Justice Melissa Standridge. I'm on the Supreme Court. Chief Justice Marla Luckert is my boss. So I hope I don't say anything that embarrasses her, that's for sure. I'm going to talk a little bit by summing up. I'm going to talk a little bit about an overview of the Constitution and include separation of powers and checks and balances. And this kind of might seem a weird place to start, but I'm going to talk about what the difference is between the Constitution and the Declaration of Independence as my introduction. The two are connected in spirit, but they are completely separate documents. The Declaration of Independence was signed in 1776, and it lists a bunch of grievances against the king to justify separation from British rule. This is the document that contains the life, liberty, and pursuit of happiness, the inalienable rights given to all of us by our Creator. The Constitution was written and signed 11 years later, and that's the fundamental framework for our system of government in the United States. It was written and then ratified by all the states. It's the supreme law of the land. And this is the one, as Chief Justice Luckert mentioned, starts with "we the people." And in talking about the rule of law, it is the supreme law, rule of law of the land. And I want to put a quote in by John Adams that we are a government of laws and not of men. And that's a critical component of the Constitution. Of course, I would change that quote a little bit to say we're a government of laws and not of individual people. because back then, of course, we didn't really count as women. Thank goodness that we have evolved since then. So let's focus on the Constitution. Again, it's the fundamental framework. It puts the power in the hands of the people. So it describes the purposes and duties of the government, defines the scope and limit of government power. It gives the system, provides a system for electing representatives. It establishes the process for ratification and amendment. It outlines the rights and the freedoms of people. It divides the power between the states and the federal government. And what I'm going to talk about more in a minute is it divides the government into 3 branches of government. But as an aside, I did want to note that as I was researching to give this presentation, that the Constitution only contains 4,543 words. That includes the signatures. Now, when you add the 27 amendments that have happened since it was initially signed, it's still only 7,591 words. Now, that may seem a lot to you because it's in the thousands, but the average length for a state constitution is 39,000 words. So the fact that it's so succinct but so important, I thought was interesting to point out. Now let's point to the 3 branches of government. And I know you all know this. There's the legislative branch, the executive branch, and the judicial branch. The legislative branch, this is all under the Constitution, the legislative branch makes the laws. The executive branch executes the laws, and the judicial branch interprets the laws. So I think it's very important to note that the judicial branch doesn't make the law. So a lot of times when we're sitting up at the Supreme Court, people say, well, I wonder why they decided to issue a ruling about this. Well, the reason why is because somebody brought a lawsuit. So we only interpret the law. It's the legislative branch that makes the law. So critically, in establishing these 3 branches of government, the Constitution, in those 4,000 words, set up a system of checks and balances to ensure that none of the 3 branches had too much power. So let me give you some examples of these checks and balances. The legislative branch makes the laws, but the president in the executive branch can veto those laws in certain circumstances. The president in the executive branch can veto a law, but the legislative branch can override the veto if there are enough representatives and senators that have enough votes. The legislative branch has the power to approve presidential nominations, to approve and control the budget, and can impeach and remove the president from office. The executive branch can declare executive orders, and those are like proclamations that do carry the force of law. But the judicial branch can declare those executive orders as unconstitutional. The judicial branch interprets the laws, but the president nominates. This is on the federal level, okay? We're only talking about the US Constitution. The president nominates the Supreme Court justices, the Court of Appeals judges, and all the district court judges in the federal system who interpret those laws. The judicial branch interprets the laws, but the Senate in the legislative branch confirms the president's nominations for those judicial positions. And Congress can impeach any of those judges and remove them from office. The legislative branch makes the laws, but the judicial branch can declare those laws unconstitutional. Now, interestingly enough, the states or the legislative branch can initiate an amendment to the Constitution. And I say the state, there's different ways that you can initiate an amendment. And Interesting to note, there have been 27 amendments to the Constitution since it was ratified in 1789, and 7 of those can be reasonably interpreted as directly superseding a previous ruling of the Supreme Court. I'm going to give you some examples. In Chisholm versus Georgia in 1793, a private citizen sued the state of Georgia. The state of Georgia didn't even respond, saying, you can't sue the state unless we consent to being sued. And this is a concept called sovereign immunity. The United States Supreme Court ruled that Article 3, Section 2 of the US Constitution nullified the state's sovereign immunity. The states, which were very surprised by this decision by the Supreme Court, called for a constitutional amendment to preclude a state from being sued without the state's consent. And that was ratified and is now our 11th Amendment. Dred Scott decision, which I'm sure you've heard of, in 1857. The Supreme Court of the United States held that the Constitution was not meant to include American citizenship for people of African descent, regardless of whether they were slaves or free. So the rights and privileges conferred on each American citizen by the Constitution does not apply to them. But the 13th Amendment abolished slavery, and the 14th Amendment guaranteed all persons born or naturalized in the United States to have the equal protection of laws, regardless of race and regardless of whether they had been a slave in the past. In 1895, there was a case called Pollock versus Farmers Loan and Trust. And the United States Supreme Court held that the federal government didn't have authority under the Constitution to levy an income tax. The 16th Amendment, which was, ratified about 15 years later in 1913, allowed Congress to levy an income tax, which of course we still have today. In the case of United States versus Anthony, not the Supreme Court, but a federal court of appeals held in 1873, that, you know what, if a state wants to deny women the right to vote, they can if they want to. The 19th Amendment, which was ratified 47 years later, guaranteed women the right to vote in all elections. Though I will say that some of the states had already allowed women to vote for decades before this amendment was passed. There were several cases which limited Congress's ability to interfere with how states conduct elections. But the 24th Amendment and the 26th Amendment prohibited states from, respectively, collecting poll taxes and requiring them to lower the voting age to 18. So we can see here that the United States Constitution is interpreting the Constitution, and that is this, that's how they're interpreting it. But at least 27 times, the Constitution has been amended, which includes ratification by all the states. I'm going to close with this. One of my all-time idols, who I did have the chance to meet, Justice Sandra Day O'Connor, had this quote about what makes the Constitution worthy of our commitment. Here's what she said. First and foremost, the answer is our freedom. It is quite simply the most powerful vision of freedom ever expressed. It's also, as I mentioned, the world's shortest and oldest national constitution. It's neither so rigid as to be stifling, nor so malleable as to be devoid of meaning. She went on to say, our Constitution has been an inspiration that changed the trajectory of world history for the perpetual benefit of mankind. In 1787, no country in the world had ever allowed its citizens to select their own form of government, much less to select a democratic government. What was revolutionary when it was written, and what continues to inspire the world today, is that the Constitution puts governance in the hands of the people. That's all I have.
I hate to add anything after that inspiring close. But we did want to spend just a minute to make a point that while we have talked much about the Constitution and the interplay as we see it day to day in our court system, to emphasize the fact that because of the rule of law, you may never have to be involved in a court process. You woke up this morning in your house feeling secure because the laws gave you, either as the owner or as a renter, the right to prohibit others from entering your premises. You may have decided that you wanted to go get a breakfast treat before you came today. If you walked or got in your car, you were probably able to do that without incident because you knew the others on the road would follow the laws of the road and yield and stop where they should. You walked into your coffee shop and you had a trust that you would be served in a manner that gave you safe food and beverage, because there's a whole world of regulation about food safety. You were able to give them cash or maybe a check, if anybody does that anymore, or a credit card or a debit card, because we have volumes on our shelves of laws that control how all of that happens behind the scenes without you having to give it a thought. And all of that, our whole society in so many ways works because we are based on this concept of the rule of law. And I will toot our horn and say it also works because people know that if there is a problem, if there is a dispute, a disagreement, we know that the court is there to resolve that in a fair and impartial way. A way where it doesn't matter the color of our skin, whether we're rich or poor, whether we're educated or not. None of that makes a difference. We do, and with maybe just a minute or two left, have one question, which is, what are the biggest threats to the rule of law in Kansas today? I don't know how much time each of you would like to weigh in on that. I would say there are two that I identify very at the top of my list, and one is misinformation, which is why I stressed the need for us to all gain understanding of some of these principles so we ourselves can be critical thinkers about what is conveyed to us in information and weigh and determine the trustworthiness of some of those statements. And the second thing I would say is the politicization of the court system. The sense by many in society that judges should be Republican or Democrat or whatever, or just a feeling that they should follow a political viewpoint. That is not what courts are. Courts are to step away from the politics, and they are to look at the law, not through the political lens, but through what does that law require? What does that Constitution say? Anyone else want to throw anything in as we have? All right. I do think we're at our time, Kathy, if that's correct. I'd
Yes.
like, on behalf of all of the panelists, to thank you for giving us this opportunity to speak with you about topics about which we are passionate, the rule of law and the Constitution, and protecting that Constitution for all of you.
And I want to thank all of the panelists for an extremely educational and informative, enlightening presentation. We got to see and hear so much about how the rule of law does impact all of our lives. And I appreciate your time spent in preparation and presenting this program. Thank you.
Thank you.